Yes, welcome to, hopefully we'll get through this. We're going to do a role-playing session, which is just court procedure. It is an episode, and not a typical episode of the No State Project, but it is still part of the No State Project. I'm not taking calls with questions on how to resolve disputes in court, but what we're doing is we're on Discord because, frankly, Skype sucks, especially, and you know that if you, I don't know if we can blame it all on Skype, what happened last week, but we're going to try to do this. So what we need you to do is, if you want to participate, we've got a bunch of some people we're going to go through it, but as we go along, because we're going to do this for about an hour, if you want to participate, then you will have to contact me at Frank Rizzo 3 on Skype, and I'm going to put that in the chat there, Frank Rizzo 3, and then I will put you into the chat, and then you can get the link to get into the Discord. So the Discord seems to, well, at least my experience works 10 times better than Skype does. So we'll see what we can get through this. So what we're going to do is we're going to be with the role playing. What we're doing is we're putting the Socratic method, we're putting it into action. And so the object is to be able to show, like when we go in the court or when we're talking to a bureaucrat on the phone, we want to be able to show that their claim against us, their legal claim or their legal determination that they have jurisdiction, for example, that it holds no water, that they don't have any actual evidence to prove that it's just their voice and nothing more. So also a heads up, you can't call me during a I hate Skype. I really do. For who's ever trying to call me, if you continue calling through here, that's not how you can connect. You have to instant message me on Skype first, and then I can put you into the chat so that you can get the link for Discord. If anyone continues to keep calling and calling and calling on Skype, even though this isn't a regular broadcast, I'm going to ban you from Skype. And it won't. And so we're trying to keep this professional. So, yeah, we're off to a rousing start. So why don't we get to this? And yes, I can't turn. All right. So I'm going to moderate this. We're going to have Bill, who's going to court soon. He's going to be the defendant, and a couple of other people are going to be playing the judge or prosecutor. So I'm just going to take a back seat, and you guys take it from there.
Yes. Hello, Bill. You're here today under allegations of violating speeding limit at so-and-so. Are you ready for trial?
Good afternoon. Do I have a right to plead guilty here today?
Yeah, sure. You want to plead guilty? Go ahead.
Well, I just have a couple clarifications that I need. Had I received any disclosure and Brady material from the prosecutor to evidence to enter a plea, we wouldn't be here today. Do I have a right to plead guilty?
Yeah. If you want, certainly we could go ahead and actually get a public defender here for you if you want to go through the evidence and things like that. As far as I know, the prosecution has submitted everything that they need to submit. So I don't know why you went back to, if you want to plead guilty, you can. So go ahead, plead guilty if you'd like.
Objection. I'm not looking for assistance of counsel. I'm here to defend myself. And if the prosecution has given facts put on their record or that evidence, he has not provided me with any, and he cannot prove jurisdiction.
Well, let's see. We have a complaint here from Officer so-and-so that you violated a law on Highway 56, going over the speed limit, and because they submitted their claim, they have jurisdiction over the geographical area, and you were in it. So they've established jurisdiction. We are now at trial. Would you like to plead?
Objection. There are no facts and evidence. Do you believe the prosecutor has met his evidentiary burden on jurisdiction?
Well, that's what we're here for. If you want, I'll have the first witness called up and we'll get them on the stand, and they'll be able to testify to your location.
Now, I'm going to just jump in here real quick. Someone tell me what the main problem was. Well, there was a few problems with the way Bill is going about doing this. But a big one really got him in trouble. So somebody want to jump in and where he went off the rail or went off went away from the program, so to speak.
He's making a lot of claims.
Allegations.
Right, exactly. So I wrote down, yeah, he's making assertions. So Bill, one of the things we want to recognize is that the burden of proof is on who?
Prosecutor.
Right. Do you have a burden of proof?
No, I do not.
All right. So when you make assertions, you take upon yourself a burden of proof. So all we want to do is we want to ask leading questions. All right. So pretty much every question, like you're on a cross-examination, pretty much every question should be a leading question. So keep that in mind. And I think that's, to me, for me and a bunch of people, hey, then that's good that people are catching that. They're noticed, the other people are noticing that that's one of the things that help get this derailed. The focus of your attention should be on the prosecutor's lack of evidence. And you started to get into that, but you were already deep in trouble. So that's why the judge could just say, well, that's why we're here.
Okay, so now what?
Why don't you start over? Because if you're going to trial and they want to push this to trial, why don't we do it in a sense in that you've filed a motion for dismissal for prosecutorial misconduct because they can't give you the evidence of of jurisdiction. They can't give you evidence of an element of the charge. And so when they're asking to be, if everyone's ready to proceed, take it from there.
Okay. Mr. Bill, we're here today for trial. And the prosecution has submitted the allegation that you've been, or the charge that you were driving 75 in a 65 mile an hour zone on Highway 56. Are you prepared?
I have a couple motions that need to be heard first, sir.
Okay, what are they?
There's a motion to dismiss for lack of jurisdiction and a motion in limine.
Oh, okay. I see them right here. Yes. Motion dismiss is denied.
Objection.
Motion.
Point of clarification.
Sir, if you interrupt this court one more time, you will be found in contempt. Do I make myself clear?
Yes, sir.
Okay. So the motion to dismiss is denied, and the motion in limine, well, that's what we're here for.
Objection. Point of clarification on the motion to dismiss.
Go ahead.
Sir, you're the one who denied it. What are your grounds?
Can I jump in here?
Go for it.
All right. Somebody tell me, and we just went through this, Bill. Says one, you don't always have to say objection, point of clarification. You can just say objection and ask a question, and say that it's unfair. What is Bill? What is the cardinal error that he's making here in his question to the judge?
You got the judge even. I have no idea.
Well, somebody who's listening, maybe someone on the Skype chat can tell me. He asked the judge, what are your grounds?
The law.
Well, I'm not looking for a response from the judge. I want to discuss what is wrong with Bill's question, asking the judge, what are your grounds, or on what grounds did you deny the motion?
Yes or no questions.
What do we call those?
Leading
Socratic.
question.
Now, Bill, do you understand the difference between an open-ended question that gives the judge an opportunity to give a narrative that you have no idea what he's going to say, as opposed to a leading question, which controls his answer and limits it to really just yes or no?
Yes, sir.
All right. The last thing you want to do is to ask a question you don't know the answer to. And you want to keep the focus 100% of the time on the prosecutor's lack of evidence. There's no denying that they don't have the evidence. The only thing we're dealing with is all the garbage, that the verbal diarrhea that the judge and the prosecutor is going to, throw out at you to deflect your attention away, that to try to convince you, well, that's what we're here to find out. And, it's like, it's called disclosure, you dickhead. They didn't teach you that in law school either. But we want to keep the focus where it belongs, on the prosecutor's lack of evidence. So I think a much better and proven effective question there is not to ask an open-ended question and give the judge an opportunity to give you a narrative, because you don't know what he's going to say. You want to ask, I would say, well, objection. Are you of the opinion that the prosecution has sufficient facts to overcome the motion, that they have evidence proving the Constitution applies just because I'm physically in Arizona? See, that limits his answer, doesn't it?
Yes, it does.
And that's what we want to do. And so it's the same thing if you're on cross-examination and you're going against a police officer who's probably been cross-examined and direct examined, 100 times, and you're a neophyte. The last thing you want to do is, on cross-examination, ask an open-ended question so that he now has an opportunity to give a narrative. And he's probably going to restate something that's going to make it look bad for you. That's why they're there. So keep that in mind. We don't want the judge to have an opportunity to give a narrative. So the judge, just go back to where you denied the motion.
The motion's been denied because under Section Penal Code 148A7025, it states that I can make that decision. So there you go. As far as the second motion, you've been informed of you were on the highway, breaking the driving over the speed limit at 10 miles an hour over the speed limit. And so how would you like to plead? Guilty, not guilty, or no contest?
Well, I'm sorry. I thought we were already at the trial and he's filed a motion in limine and a motion to dismiss for prosecutorial misconduct. So
you want me to just dismiss the prosecutorial or the limine?
We'll start back where you just say, without any grounds, your motions are denied.
Oh. Okay. Well, yeah, your motions are denied, sir.
Objection. Is it your opinion that the prosecutor has met his burden of proof and fact to establish jurisdiction?
No. Well, I'm just denying your motion. So, yeah, would you like to continue?
And what facts does the prosecutor rely on proving the Constitution and laws are applicable in established jurisdiction?
We've already established that we have jurisdiction. You're here. You're in at trial, so the facts are evident. We have a police officer waiting to testify. So, without further ado, sir, would you like to come up to the bring your first witness?
Objection. Are you withholding evidence from me?
I'm not. The prosecution might be. Did he give you all the evidence?
Then let the prosecutor present his facts or dismiss for lack of jurisdiction.
Well, you've already plead, so you accepted the jurisdiction. Now we're moving on. Okay. We have Officer so-and-so here, and I'm really getting tired of these allegations against the prosecutor. Have you any evidence that he's withholding evidence from you?
Do I have the right to plead guilty here today?
Yes. Go ahead, plead guilty.
Has the prosecutor presented evidence on the record or in evidence?
Well, you've already been informed of citation.
You got both. You guys are doing
this-
pretty bad job at addressing the issues, and I just want to point out.
Sorry.
No, it's like somebody's saying, and I think I put it in there already, that I should be the defendant. That I'm not the one doing the role playing to learn how to defend and destroy someone's argument in court. We're doing this to teach other people to do that. The point of it is, that's what the point of this is. So someone like Bill, who's going to court, who really needs to prep so that they are better. I've already got a lot of this down, and so I'm moderating this to help Bill and everybody through the process, and so that they can help learn a little better as we go on this. I think where things are a problem is the judge is not going to say to Bill what witnesses do you have. What the judge is going to do at this point, when he denies the motions and doesn't want to hear anything, he's going to deny the motions, and he's going to ask the prosecution who their first witness is. He's not going to say to the defendant who their first witness is. Okay.
Oh, that's what I thought I was doing. I was asking the prosecutor for their first witness.
Oh, because you had asked Bill.
Yeah, my bad.
That's what it sounded like anyway. And that kind of threw things. I think for the motion, now, we don't want to keep pushing things. If they're not going to answer the question, they're going to be their job is to try to get that police officer on the stand and examined as fast as humanly possible, because as soon as they get that, all they have to do is, in their eyes, and unfortunately appellate courts too sometimes, is just give you the opportunity to ask a couple of questions of the police officer, and they think due process is completely satisfied. 200 years of Supreme Court decisions would, contradict that. There's more to a cross-examination than just being permitted to ask some questions. It has to be an effective cross-examination. It's got to be meaningful. That's why a trial, to be fair, has to be meaningful. You have to have the opportunity to defend yourself, and it's got to be meaningful. That's why when the judge just denies everything without an explanation, doesn't even allow you to speak, it's not meaningful. It's not effective. You can't defend yourself when you're being constantly threatened like that. So Let's try it again where the judge, you just tell Bill, sir, your motions are denied. We're moving on.
Okay. So, Mr. Bill, your motions are denied. We are moving on. Prosecution, please bring up your first witness.
Objection. Is that your opinion that the prosecution has met their burden of proof to establish jurisdiction?
Yes, and we are moving on. Prosecution, please present your first witness.
Am I entitled to a fair trial?
Oh, hold on, Mr. Bill. This is prosecution's turn to speak. This is not yours. Please do not interrupt the proceedings. Prosecution.
Hello, Your Honor. We got the officer ready to go on the stand.
Okay.
Well, I think the problem was, and I jump into here again, in that I would still be focusing on the prosecution's lack of evidence and a serious Brady violation at this point, and not asking again if I'm entitled to a fair trial or a fair hearing. Bring it back to the prosecutor's lack of evidence, because when they go to put the witness on the stand, you have to, again, there's a serious Brady violation that has not been addressed.
Okay. And the way to do that, Bill, would be to, since you're pretty new at this, it would be to bring up your motion to limine and, ask him about that.
Well, someone, just real quick, while you guys are gathering your thoughts there, someone's asking what's a Brady violation. And so a Brady violation is that the prosecution, and it's called the denial of exculpatory evidence if you're in Canada or Australia or England. It's the same thing with in those areas where the prosecution is required to give you all exculpatory evidence or information. And that means any information that shows that you're innocent or negates guilt. And that includes, let's say, if the witness, for example, is not qualified. Now, they shouldn't be calling them anyway, but if the witness is not qualified or competent to have made certain legal determinations, and they're going to be put on the stand to testify to that, they have to tell you, since it's exculpatory impeachment information, they have to tell you, by the way, I'm putting the witness on the stand even though he lacks personal firsthand knowledge of the matters he's testifying to. They have to tell you that because no one may testify unless there's proof that they have personal knowledge of the matters they're testifying to. Rule 602, it's 702 in California. I don't remember what it is, elsewhere, but you have to have the personal firsthand knowledge. So let's address I think it's more important to address the Brady violation and then lead into the discuss the motion in limine. But the Brady violation should warrant a dismissal of the charge. And yes, this is addressed in the motion to dismiss for prosecutorial misconduct. It's all laid out in there.
All right, Bill, you ready?
Yes, sir.
Okay, your motions are denied. We are now going to call upon the witness, Officer so-and-so. Prosecution, please present your witness.
Objection, Your Honor. There seems to be a problem with the Brady material. I was not provided any Brady material, any exculpatory evidence.
Prosecution, have you provided any evidence to the defendant?
Well, Your Honor, we've given him everything we have, the ticket and the officer's notes. That's all we're supposed to provide at this time, sir.
Well, okay, well, I guess that's it. That's what they provided for you. Are you ready to continue with the proceedings, Mr. Bill?
I can't seem to get my head around. Just if you could let me listen for a little while.
All right, we can discuss this, and because one of the things that I mentioned that you would need to bring up at that before when you make the objection to the witness being put on the stand is not only have they not given you the any exculpatory evidence, they have presented no proof whatsoever that the witness has personal knowledge of the matters that they're being called to testify to. It's the proof of personal. So the judge more than likely is just going to, he's just not going to dismiss for a Brady violation. He'll just blow it off saying, if you don't believe the witness has personal knowledge, I'm sure that can be brought out on cross-examination. So you want to address before the part of the objection has to be that the prosecution has no proof that the witness has personal firsthand knowledge of the matters that they are there to testify to. And as I've said before so many times, the cop, his prior testimony is that you violated the law, that the laws apply to you, and that you violated them, and he's going to be testifying that the laws apply and you violated them. So that's something that they have to have personal knowledge of. Now, personal knowledge can come out in his testimony. Sure, that's what the rule says. They can bring out the personal knowledge in the testimony. However, that's what he's going to be testifying to, and the proof should be given to you prior. So the prosecution should have given you in the response to the discovery Brady request some of the information that the police officer was relying on, or he's relying on, to show that the police officer has personal knowledge. And one of my things that I've personally seen, I know it's anecdotal, they don't extend us the same courtesy. If you were to pull somebody out of the audience and just say that you're going to put them on the stand to testify, the prosecutor and judge would go ballistic and insisting that they can't testify because they don't have personal knowledge. You have no proof of personal knowledge of what they're going to testify to. So that's a really important thing to bring out. It doesn't mean for a second that they're actually going to say, yeah, Rule 602, it does require personal knowledge. So, Mr. Prosecutor, do you have personal knowledge? Do you have proof that the officer has personal knowledge, that the laws apply? Since he's going to be testifying to that? They're not going to do that. Their idea is that due process is satisfied when they put the cop on the stand and you get a chance to ask questions. Now, no more context is needed for these people. You had your day in court. You had an opportunity to cross-examine the police officer, and you just weren't persuasive. You just didn't do a good job. It wasn't persuasive. So they need to be able to have personal knowledge. You need to be able to ask them leading questions in order to, and ask them leading questions on their prior statements. And they don't typically allow that. This is I'm not going to be able to get that. Are there any questions regarding that?
No.
So you're pretty good. Yeah, so you're pretty good on that. So we can take it from there, and you can make your objection and address the issue of the witness's lack of personal knowledge.
You ready, Bill? Write this down. Prosecution has not submitted any evidence to show that the witness has firsthand knowledge of the accounts or the matters he's testifying to.
Can you repeat that one more time?
But you gotta put it in a question. Objection. Has the prosecution submitted any evidence to prove that this witness has firsthand knowledge as to the matters he's testifying to. You got it?
Yes.
Okay. Okay, so your motions are denied, Mr. Bill. Let's go ahead and bring up the officer in court so that he could testify and let you know what's going on. Prosecution, please bring your first witness.
Objection. Has the prosecution submitted any evidence to firsthand knowledge to matters he is about to testify to?
All right, I got to jump in here. Are we able to get somebody who's not quite as new to the to role playing?
Yeah,
to
somebody
help
else has
out?
got some.
Anybody else
Sorry.
who's done it before can jump in and help out, make this go a little smoother? I didn't want half the role playing session to be silence.
No, it's I'm sucking at it too, dude. Don't worry about it, Bill.
I just want to be able to make it a little more effective of a session.
Well, Mark, may I be so rude as to say, can you not be the prosecutor, the judge, and stopping it and explaining things where he goes right or wrong? And that would really, really help out even the so-called advanced people, I think, just my opinion, again. But I don't have a black robe, I'm sorry. Just an opinion.
You want me to stop jumping in and making corrections?
No. I want you to be all of it. I would love to hear Mark doing all of it. The judge, the prosecutor, and to stop him and say, here's where you're going wrong. This is where you could go. This is where you might go. And this is what you might say or might not. Or, like actually, like a one-man show.
Well, here's my thoughts on it. The thing that needs to happen is people need to get a good understanding of this before they start role playing. And we're dealing with somebody here who just joined today, which is, it's what it is. But you got to get this together, and there's a lot of concepts to understand before you get moving forward.
Yeah, and I get what you're saying about me doing it, but the point is not for me to just do a show and just go and discuss these issues. It's got to be that people are getting their feet wet, and even if that just means like what we're doing now, where wow, I need to listen to this for a bit longer, and then I'll jump in again when I'm a little more comfortable and a little more familiar with the principles. So, I mean, I'll jump in and play a judge, but I don't want to do all three and just really just start doing another broadcast like I do Wednesday and Saturday. I mean, I've done that enough on the show, and I have discussed these principles enough on the show that I don't need to spend this time doing that. I could just do that on the Saturday show again. I want people to actually start sparring. And again, even if it's just to say, holy crap, I'm not even remotely prepared to go to court, because I see the value in that. We don't want to go to court when we're not prepared, because it can be brutal, and you could lose your liberty. There's always that risk. Well, hell, you could be as prepared as Jerry Spence and have your cell phone go off and your butt's going to jail. But we don't want it to be that you are so unprepared that you make things, potentially worse for you. Really, you go in and do something like Bao did, like I found out yesterday because I didn't know about that start playing the name game. It's someone told me the other day, well, it was on the console where I just want to throw everything at them. I'm like, that's a really bad. That's not good. So why don't we just first try to see if we can get someone else here. And like I mentioned earlier,
Put me on trial.
I have no toleration for trolls right now.
Don't feed the trolls.
I keep telling people that, and I'm just going to keep putting her and anybody else in timeout, and because I'm not going to give anybody an opportunity to engage them. But
All right. So put me on. I got arraignment tomorrow.
you have arraignment tomorrow, and what was your name?
Home bombing it.
Home. I'm sorry, I didn't. So all right. So why don't you take the chair, the defendant's chair?
All right, Mr. Home Bombing It, you've been charged with sitting on your butt on the street, and that carries a big fine and jail term. How do you plead, sir?
Oh, yeah. Am I presumed innocent still today?
Sir, you're presumed not guilty. Everybody coming in my courtroom is presumed not guilty of any crimes as of yet.
Okay. Well, I can appreciate that you keeping my status, or you're presuming me not guilty, but are you presuming me innocent?
Well, yes, sir. That's kind of another one of those synonym, and please stop with the diatribe. It's the same thing, sir. Now, yes, come on, move on. How are you going to plead? Guilty or innocent? Guilty or not guilty?
Oh, thank you for answering that with a yes. Do I have a right to be informed of the cause and allegations of the proceedings?
All right, sir. You're getting to agitate me. Are you one of those sovereign citizens, constitutionalists or something, sir? Because I'm hearing a lot of strange questions from you, sir.
No, I'm none of that. I'm not. Yeah, I'm not affiliated with anything.
Then what are your
Do I have? But
clarifications?
I'm wondering. Do I have a right to be informed of the cause and nature of the allegations and proceedings? That's all I'm asking.
Sir, if I have to read these out again, sir, you've been charged with sitting on your butt on a sidewalk pursuant to Criminal Code XYZ. I'm just here to take a plea from you, sir, so we can have a trial in a little while. How do you plead, sir?
I can appreciate your.
All right, I'm going to jump in here. And do we have a Canadian playing the judge?
I'm sorry, I'm from Earth there, Mark.
Are you from the part of Earth that's the northern part of North America called Canada?
Oh, the landmass. Yes, sir. Absolutely. Yes, sir. I
Yeah,
believe so.
Yeah.
What? My accent is worse than
Mine? No.
Yeah.
No,
Oh,
it's
okay.
just you said Zed, and most Americans don't say Zed unless they're Rush fans. So I want to just jump in here because we had this problem before. What we want to do typically, and I know you've been able to do this, Home Bumming It, is when we go in, we want to ahead of time file the motion to dismiss or the demur and the discovery/Brady request. So that is what we are usually going to go through when they say, sir, how do you plea? And then you can say, there is a demur pending, sir. So why don't we take it from there? And yes, Rush. For those who aren't aware, I'm going to take just a slight detour here. It is not YYZ on moving pitches. It's YYZ. So when it comes to Rush, I will split that hair because it's Rush. And for those not familiar with Rush, just tune out right now. We're not interested. So I don't know how that's even possible that someone cannot be familiar with Rush. Anyway, from the top there, tough guy.
Yes, sir. I just got out of my Z28, parked it in the judge's spot, judges only, and back in the court with my dress on. Sir, it's very simple. How do you plead, sir?
I submitted a motion to dismiss and a Brady request. Have you had a chance to read those?
Oh, I see something. Let me go. Let's see. Yeah, there it is. Interesting, nice paper. Denied.
Am I presumed innocent here today?
You're not gonna ask me why, how, or anything. I denied it. Do you object?
Come on.
Yeah.
That's
Come on,
not what a
home
judge
bombing
would
it.
say.
He denied your motion to dismiss or overruled your demurrer. What are we interested in doing here?
Has the prosecution submitted any facts to presume that the court has jurisdiction over me here today?
Well, a better way to say it is objection. So is it your position that the prosecution has sufficient facts to overcome the demurrer?
Okay.
Do you get the difference in those in what I said?
Yes, because I'm referring back to the Demurrer and I'm asking him for the facts and evidence that they've had to overcome it.
If they have sufficient facts to overcome it, which limits him to a yes or no question. It's just a leading question. So objection. So it's your position that the prosecution has facts, sufficient facts to overcome the demurrer. And you could throw in, and probably should, namely that that there are facts proving that the Constitution and code apply just because I'm physically in California.
Okay. So go, Stahl.
Sir, as I've told you, I've looked at your motion. I find it frivolous. There's nothing in this motion. It looks like some internet garbage mumbo jumbo. I've denied it. Now move on. How do you plead, sir?
Objection. Point of clarification. Has the prosecution submitted any facts into evidence to overcome the demurrer?
Sir, the prosecution has provided the prima facie for us to have jurisdiction to hear this matter, and then therefore, please don't frustrate the court proceedings and refusing to participate and refusing to plead. Now, sir, how do you plead? Guilty or not guilty? If we can't get that from you, sir, we might have to assign you a lawyer to help you out, to help your defense, because this is your life that we're playing with, you know, sir.
Objection. Point of clarification. I can appreciate the legal advice, but I was wondering, does the prosecution submitted any factual evidence or any facts into evidence that would overcome the demurrer?
Throw him in jail, Stahl. Just throw him in jail for contempt.
Really? Me, I would have said, all right, tell you what, I'm going to be fair, impartial.
No, you wouldn't. Not based on what you've done so far. You've already.
I looked at the prostitutor and I would say, prostitutor, have you filed anything? And he would just say, oh, yeah, we gave him the officer's notes and whatever the usual, just to circumvent the whole thing. And
well, you're at arraignment, so the prosecutor's not going to be there. So because of how forceful you were, I that's why I cringed for those who were following along on the YouTube stream. At that point, home bumming it, like you've already, about the unsigned plea of guilty. If he's absolutely insistent and he's saying that he's going to probably assign you counsel, you've pushed it as far as you can. You made your objection. You preserved the error for appeal. So don't push him any further, especially in California, because your psych eval might be coming next. I will go right into, because he says about entering a plea, I go right into, I'm happy to plead not, I intend on pleading guilty, and you know the rest. So Stahl, why don't you just yell at him that he needs to either enter a plea or you'll do it for him.
Oh, wow. I love that. That takes all my aggression out. No. Sir, it's simple. Guilty, not guilty. And if you don't come up with one of those or the other, you will be held in contempt of court. Do you understand me, sir?
Sir, I have an unassigned plea of guilty here today that I am not against signing. I'm just trying to be informed. Has the prosecution submitted any evidence into facts or any facts into evidence to prove that the court has jurisdiction to impose on me here today?
Okay, let me jump in. When you're at this particular point, it's not correct to say entered facts into evidence. He only has a prima facie burden at this point, and all he has to do is have it in the record what those facts are. You're not entitled to, to cross-examine or do anything like that now. It's just a matter of prima facie. Do the facts have any chance, even the slightest chance, of proving the prosecution's claim? So we don't want to always say facts in evidence, because that is only appropriate when you're at trial or after trial. So just keep it to the facts. And I know that may sound like I'm splitting a hair, but I got to tell you, if I didn't have so-and-so on, she'd be going furious right now with all her insults. So there is a difference. And so we need to be aware of that. Especially when in the other scenario, they were right before they were going to trial, and it gives the judge an opportunity to say he hasn't put anything into evidence yet. That's what we have a trial for. At the trial, then he can move to put it into evidence, and you can object. But right now, he just has a prima facie burden. He just has to have the facts in the record that if, with even the slightest chance that they prove the allegations, then that's sufficient. See, our job is to question him and bring out that there's no chance that those facts prove the proposition or the claim. No chance. And there isn't, which is why they say they don't have to prove it. So we're running really
has the
low on time.
prosecution submitted any facts? I'm sorry.
You're right. You want to say objection. I intend. You say you say way too much. You want to keep your question short. Objection. I intend on pleading guilty. Has the prosecution submitted facts to meet that prima facie burden? Any facts that would prove that the Constitution and Code apply, just because I'm physically in California?
Okay. So has the prosecution submitted anything to presume that prima facie case is no? Oh, man.
Yes, the answer is yes. Yes, sir, they have. Now where do you go?
What facts has the prosecution submitted that the codes and laws that prove that codes and laws apply to me just because I'm physically here today?
Sir, the facts have been given to you. Did you not receive any response from the prosecutor? Yes, sir. Well, we did kind of respond with him back and forth through email and stuff, Well, there you go. You have some facts in front of you, don't you?
Well, factually, all I have are these written instruments. I was wondering how would those prove that the codes and laws apply to me just because of my physical location?
Sir, are you trying to say that the law doesn't apply to you, sir?
Sir, these are not my allegations. I'm just inquiring about the prosecutor's allegations that the codes and laws apply to me. And has he submitted any facts of the allegations?
Sir, listen. We have jurisdiction to hear this matter, and we have jurisdiction to have a trial here. Now, I just want it guilty or not guilty, and so we can move on to trial, sir. Do you understand that?
Hold on, let me jump in because I'm pretty much out of time here. I want to address this issue here. When the judge mentions something specific like the ticket, and he's saying you got the ticket, that's when we say, so is it your position, sir, that the facts proving the Constitution apply to me because I'm physically in California are on this ticket? And then If he says yes, what would you say, home bombing? What would your next question be?
Isn't this a written instrument?
We already know that. That's obvious. He has gotten you very specific. He's telling you, even though he doesn't realize, he's telling you something that is absolutely not true, that the facts proving the Constitution applied to you are on the ticket. So remember the six honest men. Who, what, where, when, why, and how. Which one of those would make a better question to ask him in that situation?
How does this ticket prove that the codes, laws, Constitution apply to me just because I'm physically here today?
The better question, more effective, that doesn't give him nearly the wiggle room that question does, is to ask him exactly what on this ticket proves that the Constitution, a written instrument, actually applies to me because I'm physically in California. What on this ticket, sir?
How about is the only thing the prosecution is relying on is this ticket to prove jurisdiction?
That's kind of obvious. I mean, that's usually, you can ask that. And I've had the judges just on their own insist that the ticket is what they use as evidence of jurisdiction. But yeah, you could ask that.
So would that not work into a verbal sort of motion in limine? So basically saying, okay, that's the only thing the prosecution is relying on as evidence to support his allegation of the code's applicability. Then the next step to that would be, isn't the ticket nothing more than an evidence of an allegation?
Yeah, but I think in my experience, it's easier to go, and it goes naturally this way when they insist that the ticket itself is the evidence that, or has the evidence. And so it's easier just to go for the throat and just say what exactly on this. Once you get them to confirm. So you're saying that this ticket has evidence on there proving that the Constitution, a written instrument, applies to me because I'm physically in California. And I said, well, yes, of course. In my experience, just saying what specifically on here is evidence proving or facts proving that your Constitution applies just because I'm physically in California. Every time
go ahead.
Every time I've done it, I've been able to get them to realize the mistake that they made, and they'll say, well, the ticket's really not evidence of anything.
The only reason I say that is because they might point to the physical location later on, but you just asked if the ticket was the only thing that they were relying on as evidence. So now they want to start adding things after they said that's the only thing.
Well, they're going to be able to say, well, the officer's testimony, and then you're stuck saying, well, isn't this the officer's testimony? Isn't this a prior statement? He signed it on the penalty of perjury, or he's certified. These statements. These are prior statements. I still think it's easier and more effective just to go and have them say that the ticket, like what the judge did, is, well, you have the ticket, and he's, well, is it your position that the facts proving that the Constitution and code apply to me are on the ticket? Well, yes, of course, you jackass. And, and they say, well, then you just get specific. In my experience, once they're that specific and I ask him what exactly on this ticket proves, or if taken is true, it proves that the Constitution, a written instrument, applies to me just because I'm physically in California. That to me, is the path of least resistance and more effective way of going about it. Because at least in my experience, they don't have anywhere to go now. It's either on the ticket or it's not. Because the next thing you're going to do, well, what I would do is I would ram my plea of guilty down their throat. Sir, if those facts are really on this document, I will plead guilty right now. What specific facts prove the Constitution applies to me just because I'm physically in California? Go.
The tactic I'm kind of referring to, though, is, isolation, just so that they can't bring something else up later.
Yeah.
So if the ticket is the only thing, now we can talk about it, so that they can't bring something else up later.
Yeah, and again, you can ask that. Typically, they'll tell you that. So yeah, you could just ask an additional question and then try to hold them to that. Sure, but generally they will say that for you, that the ticket is the only evidence they need, and that's what they're going on based on jurisdiction. But in the off chance that they don't say that, sure, you could ask that as one of the initial questions.
Right. Just get that admission first as part of the Socratic method is all I'm getting at.
Yeah, yeah, you know what the claim is now, and it's a matter of asking questions on why they believe that that's true. Why do you believe that this ticket is actually evidence against me?
How is why a leading question?
Well, we're not able to ask just leading questions. I mean, you could put in there, why do you believe that this is evidence proving that the Constitution applies to me? Is it because of my physical location? So you could frame it that way.
A ticket is an allegation, correct?
Yes.
So you're telling me that the only evidence they have that would establish jurisdiction would be an allegation itself?
Well, it has an allegation of the law, that you broke the law, and there are factual statements considering where you were on that particular time, what kind of car you were driving, the time of day, the day of the month that it was. So there are some factual there are some statements of fact in there.
Well, that's great, but do any of those statements of fact show that the code was applicable to me?
If it shows that you're physically in California, yes, it does.
You're telling me that someone writing on a piece of paper that you were here is evidence of more than just a physical location?
Oh, you had me. You had this judge, and then you asked an extra question you didn't need to do.
Damn it.
You've got me right on the cusp of holding you in contempt and raging and rage quitting on you.
What should have been said?
Exactly how? And that yes, it's an open-ended question, but we already know the answer to it. And so an open-ended question is okay when you're really good and you know the answer to it. So I've done this 1,000 times, and I know what the answer is going to be. They're not going to be able to tell you. They can't. There's no way to explain exactly how your physical location somehow proves the Constitution applies to you. It's not even remotely possible. You go back to my call of shame from the other day, right? So there I would excuse, because we know what the answer is. We know we've got him up against the wall and there's no getting out of it. That's the point where the judge is going to rage quit on you, or he's going to say that that's for trial or some stupid thing like that. And in that case, I was, no, whoa. All you've got to do, because I'm not seeing it. My position is, and I know this is an assertion, my position is they have not made out a prima facie case. But if they have, if you think that they have, and you can show me how they've made a prima facie case. Remember, prima facie case is not for trial. We can short circuit that by because by using the phrase prima facie. Prima facie has got nothing to do with trial. Trial is beyond a reasonable doubt. Arraignment in pretrial is prima facie. So then you can bring that in. If you can show exactly how, or had the prosecution show exactly how my physical location has anything to do with proving the Constitution and code apply to me, I like to see it, because I will plead guilty right now.
Right, and not agreeing or disagreeing at this point. I see what I was trying to do is saying the ticket is, if they said they wrote that on the ticket, that is evidence of your physical location. Great. Now you're telling me that the code is applicable. What evidence do you have to rely on, or have you received from the prosecutor to rely on, that would connect those two to make it not a non sequitur?
Well, I'm not getting into these Greek things that or these Latin phrases that you're saying. And this is just a traffic arraignment, sir. But if you're physically in California, and I see that you're here at least today, I don't know about the day in question, but I know right now, if you are physically in California, we have jurisdiction over you. The court has jurisdiction over you.
So you're telling me you've received this information from the prosecutor?
A better thing would be to say, objection, is that because you say so, or because the prosecution's evidence does?
Right.
I just think
you
it has more
received
punch.
this evidence or this information from the prosecutor. What I'm seeing here is it looks like the prosecutor and the judge have this information. When do I get to see it?
Still better to say, objection, is that because you say so or because the prosecution's facts do?
Right.
It's short, to the point, and he's got no way out. If he says because he said so, we object, objection, outside the pleadings. And if he says the prosecution's facts say that, then you're back to home, first base, and exactly how. Or you can even go say, so you're saying that there's a slight chance that my physical location proves the Constitution, a written instrument, actually applies to me. There's even a slight chance of that. We want to play that so-and-so's game.
Did I become the chattel of the jurisdiction that I entered into? Is it just because of my physical location?
Well, you got to keep it focused. Don't throw in you don't need some. I wouldn't put anything like that in there. I would just keep it strictly on their claim is that if you're physically in California, then the Constitution and laws apply, and that gives them jurisdiction. You don't have to muddy the waters and throw in chattel, because you say something like that, they can say, I think what we got us here is a bona fide sovereign citizen. And there's a very nice, newly washed and cleaned jail cell for you, sir. So,
Hey, Judge, why haven't you asked the prosecution, or are you adding to the prosecution's pleadings here today?
well, that's the thing. I just mentioned that it could be outside the pleadings, but it depends on how he answers the question. Is that because you say so or the prosecution's facts do? And that's why I mentioned if he says, because I say so, then objection, that's outside the pleadings, and you're covering the prosecution's burden. So
I'm just trying to find something more damning.
More damning? Okay. Have you heard the call of shames when I've done this?
Yep.
And do they get past that particular point? I mean, I just did this the other day. Were they able to get past that point? Sure.
That's a phone call where you're not directly under a threat of violence, though.
Yeah, but you still want to be, you don't have that much time, and you've got to be as effective as possible. And that means asking only the right number of questions to meet your objective. And so what you want to do is throw some extra questions in. And I'll say, for a lot of the time, you're going to have a judge. We've all had people report, we've heard of people report where the judge answered questions for like 15 minutes. That's great. I don't prepare for court that way. I don't prepare for court that way. I don't think that any of us. I think that we have to do is, when we're talking about an arraignment, we have to focus on, we're only going to have 5 minutes at best, and we damn well better make this count. That's the way I look at it. If you get more time, fantastic. But look at the difference between my call of shame and the call that Robbie had. And we may have had different objectives. I thought the objective was to get them to understand and realize that they were contradicting themselves and that their claims had no merit. I was able to accomplish that goal with just a few questions and in less than 5 minutes. I don't think that Robbie met his goal, and it took 47 minutes. So you want to focus on, how do I get this job done as quickly as possible before they start raging and just throw me out and give me a court date. And I think that's the better way to prepare to go to court, is to focus more on the worst case scenario. Yes.
Well, and then the question comes down to, is your goal trying to get out of your situation, or is your goal trying to expose the complete, utter ridiculousness of everything they're trying to say?
Well, I get that. Now, if you look at the call of shame that I did with this tax agent, did I completely and utterly destroy at least her credibility?
Yes.
Absolutely, but not in a way that most typical sheeple would recognize.
There are other call of shames that illustrate that a lot better, as opposed to that, because that was a pretty fast call. I think that the average person with just a couple of pointers would see. I don't know. I still want to err on the side that the average person would listen to that call and say, that that was wrong, if that didn't seem right, especially if I could have gotten the one from the other day in California, which I really need to find the time and edit, because it's even better, because she lied through her teeth, saying she never said that the tax code was evidence proving the Constitution applied. She just lied. So I have to get that post. So maybe that is a little bit better of an example of completely annihilating someone's position in only 5 or 6 minutes. And so I'll have to get that post.
You don't think that the average dumbass would listen to that thinking, oh yeah, another sovereign free man on the land, thinking the laws don't apply to him?
Well, I think that a lot of people, a good percentage, would say that, but I think if they're actually listening to the call, I don't make an assertion. So it's something you have to, at least if I had the opportunity to speak to someone about that, and I could really, did you ever hear me make an assertion that the laws don't apply? Now that could be assumed, yeah, and that's a likely scenario, but I guess even after all this crap with Facebook, I want to give the average person a little bit more credit than I would.
Right, and to be honest, that's where I see it's a little different with what Robbie approached, was because the average person that actually took the time to listen to that whole thing, Robbie got a lot more admissions out of him than just a typical straight to the throat approach. One might be effective in one situation, but another would be more effective when you're trying to appeal to the sheeple.
I think I certainly, if I have a police officer, well, look at the difference. This is, I think, a better comparison for what you're talking about, dude. I had a 46-minute phone call with a law professor, and he talked a lot. He's a nice guy. I enjoyed the conversation, but compare the admissions I got from a law professor from the admissions that Robbie got. Didn't a law professor agree that jurisdiction is not, he said flat out, it's not based on evidence or argument. It's a blunt assertion of power.
Yeah, the Robert Diab one, that was gold.
Yeah,
So,
I like that one too. It had a lot of narration in it where you were going over his questions and pointing out the fallacies in it.
and he handled it pretty well. He seemed like a real stand-up guy. I remember looking at the time and being floored at how much time had gone by that we were on the phone. I planned to speak with him for 10, 15 minutes, that's something, because most of the other people just slammed the phone down screaming that I was some kind of idiot. So
you ever hear the interview with Robbie and Joe with Lawrence Taylor?
Lawrence Taylor? I only know of one Lawrence Taylor.
I'll send you the link.
And I remember because Lawrence Taylor was the one that broke Joe Theismann's leg. Wow, that was brutal. I remember when that happened because I was still back on Long Island. I still watched the Giants. And when the party is like, yeah, good.
We may not be speaking of the same one.
No, it's not the same one. Lawrence Taylor was a linebacker for the New York Giants back in the late 80s, early 90s. And, there was always that big rivalry.
That guy was a real piece of work.
He was quite a football player. He was the one that broke Joe Theismann's leg, and Theismann, of course, was on the Redskins, and the Redskins had always historically beaten the living hell out of the Giants. So some of us were like, yeah, okay. I don't feel that way now.
Mr. Stevens.
Yes, I have to go after this, but what can I do for you?
I was going to say, Mr. Stevens, tangent, what does that have to do with your plea of guilty, sir?
Well, I figured if we had football in common, maybe you go a little bit easier and treat me more like a human being, but apparently that didn't work out too well.
I'm sorry, we shoot pucks here. We don't know anything about this thing that you're speaking of, throwing balls around. That's ridiculous.
Oh, come on now. There's a Canadian Football League. Of course, you know that. All right, boys.
In California, that happens a lot.
Yeah, I'm sorry. I do have to go. It's way past time, but we did start a little bit later. I will keep this up there. So before I sign out, I will. I just want to let everyone know I appreciate the time and the effort you guys put in to help you put in to help each other. And I want to thank Brent. I'll thank Brent again for Saturday's show, for the support of the show. I really do appreciate that, and allowing me to be able to spend the time doing this. And I'll do it as long as I can in the foreseeable future. We will be live on the Saturday broadcast, so that is a more appropriate time if you want to call with questions regarding court procedure and being more effective in court. And we'll do some role playing on there also. So I'm going to sign off. I appreciate everyone tuning in. Till Saturday, salud.
Pleasure as always.